Hi everyone, my name is Lucy Jewell and I am a professor of law at the University of Tennessee College of Law. I teach courses in legal writing and I undertake research about legal rhetoric and its impact on the legal system and society. After the killing of George Floyd, Ahmaud Arbery, Breonna Taylor, and so many other persons of color, we wanted to re-examine the questions. How did we get here? And what is it about our legal system that institutionalizes racism and allows tragedies such as this to happen? We decided to take a look at legal institutions and structures that may have laid the groundwork for these terrible events. In this brief video, I will focus on one aspect of the problem, namely how legal reasoning itself has perpetuated racial inequality. So my thesis here is that the structure of legal reasoning has produced racial inequality in our legal system. And when I'm talking about the structure of legal reasoning, I'm talking about Aristotle and his model for reasoning, which is the syllogism. The syllogism is also the foundation for IRAC. So the classical Greek syllogism contains 3 lines. All men are mortal. Socrates is a man. Socrates is mortal. Now this seems perfectly fine, perfectly reasonable, but I do think it is relevant to look into Aristotle and to note that at the time that he was formulating theories of persuasion, those theories of persuasion were not inclusive. Aristotle himself believed that slavery was natural and that all things should be ruled or should rule. He did not include women in his persuasion theories. He believed that silence is a woman's glory. And so we have a problem going all the way back to our foundations for legal reasoning, a problem of inclusiveness. So let's talk about a few cases where the logical deductive structure has been used to perpetuate racial inequality. The first example is the Dred Scott case. In the Dred Scott case, Mr. Scott sued for emancipation. He sued because he traveled outside the state of Missouri to a place, the territory of Missouri, where slavery had been abolished. And he argued that because he left the state of Missouri, he now was entitled to his freedom. And in that case, you see a very logical argument that the court accepted, which is that people of African descent can never be United States citizens. They cannot have access to the U.S. courts, and they cannot sue for their freedom. The reasoning in that case was rock solid in terms of its logical structure. The problem was the foundation of the rule. Another example comes to us from Plessy versus Ferguson, which is after the Civil War. And this is the case that allowed Jim Crow to flourish in the South and even outside of the South for years until it was overruled. In Plessy versus Ferguson, Mr. Plessy sued and argued that Louisiana's segregation statute, which mandated separate train cars based on race, was unconstitutional. And the court heard the argument, but nonetheless decided that the separate but equal rule was a mere legal distinction. It did not violate the Equal Protection Clause. And the court went further to say any feeling of inferiority that comes from having to ride in a separate car, that's not in the statute. That is there because people of color are putting it there. This decision ignored the context and ignored the true reality, which is that the cars that were available for people of color were inferior. They were known as the dirt cars. But the judge put the case holding in the form of a very clean, logical structure and did so in a way that perpetuated Jim Crow racial segregation for years. Another problem here is that at the time, all of the U.S. judges deciding the law were white, they were all men, and they were all upper middle class. These are the judges that are deciding what is reasonable. You think about the term reasoning, reasonable, it is prevalent in our legal system. What is the reasonable person? What is reasonable suspicion? What would a reasonable police officer do? And part of the problem here is that the people who are deciding that standard are deciding it from the vantage point of a very limited place. So legal reasoning can create unjust outcomes because it creates rigid categories. These categories, because the law gets repeated and it gets cited over and over again, these categories become entrenched. And as a result, we begin to think, well, this is the way things just are. Even today, if you go onto Westlaw, you will see examples of harmful categories that abound in our legal system. We still refer to immigrants as aliens. Master and servant still crops up as a product of employment law. And Indians is still a category of people that the law adheres to. So when rhetoric dehumanizes people, when we don't actually treat people as human beings, and it gets reiterated over and over again, it produces entrenched thought patterns that can reinforce discrimination. Based on the cases that have decided and created these unjust outcomes, the trouble is that it's very difficult in the structure to bring in outside viewpoints, context, and to bring in other types of narratives to help us decide cases. However, there are instances where legal rhetoric can transform society. And one great example is Brown versus Board of Education, which was decided in the 1950s. Brown versus Board of Education overturned Plessy versus Ferguson, and it did so through the use of a syllogism, a powerful syllogism that persuaded the Supreme Court to hold that separate but equal was actually violative of the Equal Protection Clause. Separate but equal harms children, and because of its harm to children of color, it must be overturned and society must change. Another example comes to us more recently from a case in Massachusetts from 2016, where a judge was considering whether or not a person of color, a male person of color, whether his decision to flee the police was reasonable behavior or was suspicious behavior. And in this case, the judge looked to the context, looked to the history of racial profiling, and concluded that if you are a male person of color and you decide to flee from the police, you have a good reason to do that, given the history of racial profiling in this country. So there are instances where we see judges infusing their reasoning with other perspectives beyond the limited white male upper class vantage point. I'll conclude by just saying that as lawyers, we have to realize that words are powerful. We are trained in the art and craft of finding words to persuade, and we have the power to use words to transform society. Thank you.